Good morning, Ms. Judge.
Good morning, DCJ.
How are you?
As well as can be. Under the circumstances.
Yes, no, just relax. You will be fine.
Thank you, DCJ.
You hold 2 law degrees, a BProc and an LLB from the University of the West. Then what is UNIPO called now?
University of the Northwest, DCJ.
Of the Northwest, yes.
Yes.
UniWest is the acronym.
Yes.
Okay. You started your career at the sidebar. You were an attorney for how many years?
After admission, I practiced for about 2 years with a firm of attorneys, and then I went to the law clinic as supervising attorney for a year. Yes, so it was about 3 years, DCJ.
All right. And then you chose to go the route of the bench. You became a magistrate.
Yes, in fact, when I was in the law clinic, one of the students that was doing the course I was supervising was a magistrate. And he then said to me one day, you know, the way you are presenting the class and dealing with the disputes, you might be fit for the bench. And I thought about it, and I applied, and the rest is history.
All right. You were appointed as a magistrate in 2001, held that stint until 2004, and then became a regional magistrate in 2004 still.
Yes, this is
which is where you still are. I'm sorry. We had a grueling week last week, and the weekend was no better for me, so you'll forgive me if my head is everywhere.
Okay,
You were a regional magistrate until 2016.
yes, this is
And then you were appointed as a judge in 2017.
Yes.
Okay. You have acted in this position which you seek now, the position of Deputy Judge President in the Northwest Division was it for a term in 2019?
Yes, I acted in 2019 for a term, DCJ, but subsequent to that, when the JP assumed office in August, his first order of business was to appoint me as the acting DJP for the division. So I'm currently the acting DJP of the Northwest Division, yes.
How have you found that experience? Or what has it taught you? What has it shown you?
It has shown me that I do have the required skills to lead and to manage and to guide as well, as I have experienced from practice and from the time I was a magistrate. Because when I was in the law clinic as the supervising attorney, I had the responsibility to oversee the day-to-day running of the law clinic. And I had to make sure that files are kept properly. In addition to supervising the students as well, I had to compile the statistics for the cases that we were dealing with in the law clinic, on top of supervising the students as well. At that time, the post was a funded position, so I had to report to the funders about what was happening in the law clinic. So I had to compile reports as well in relation to that. So that's where I first started to test my skills, whether I could lead and manage. And then as a regional magistrate, I was in what we call a one-man station in the regional court, where I was the only regional magistrate sitting in a court, and that was in Lichtenburg. I managed the court, I chaired the case flow management meetings, interacting with the relevant stakeholders to see to the day-to-day smooth running of the court. And now, acting in this position as well, it has also taught me humility as well, and to be open-minded when dealing with people, because in that position, at times you even have to be a leader to people who are more senior to you, and you have to have the proper temperament to be able to deal with those people. And basically, that's what I've learned in this position, DCJ.
Well, you are borne out by your colleagues in the division who've done something unusual and nominated you.
Yes.
Did not just nominate you, wrote a glowing testimonial for you. So it does appear that you're doing something right there.
We are a family, DCJ, in that division. You know, if you want a true definition of brothers and sisters, you should come to the Northwest.
That is the sense one gets. Well, that's very good. I hope the other divisions can replicate that collegiality which the Judicial Code of Conduct requires of us.
Yes, DCJ.
I saw something quite interesting in your CV. You attended a Stephen Covey leadership workshop. I mean, he is the doyen of leadership etiquette. Where was this?
Yes, this was a workshop that was arranged by the former CJ, Mogoeng. He was the JP then in the Northwest. He arranged a workshop for judges at that time, and he invited the regional magistrates to attend that workshop. It was on the 7 habits of leadership.
Yes.
Yes, very interesting workshop.
I
But
can
it's some time
imagine.
ago, yes, DCJ.
You are one of the network judges on the Hague Convention on the Rights of the Child. Do you still hold that position now?
Yes, I still do DCJ.
Okay. What is the gender and race composition of your division?
We are a composition of 7 judges, but currently DCJ, we only have 4 permanent judges in the Northwest Division. And of the 4 permanent judges, we've got 2 women and 2 males. I'm the only black female in the division, and we've got a white female, and then we've got 2 colored males. And we have 2 acting judges currently, and it's 2 black females that are acting in the division.
So you are on a rebuilding mission, as it were.
Yes, DCJ.
Okay. There are 3 complaints that were lodged against you with the Judicial Conduct Committee.
Yes, DCJ.
I am not going to ask you about 2 because I know that rulings have been made there and they will be issued probably today even, and you were absolved. Those are the matters of complaint lodged by Mr. Mbembe against you and the retired Judge Lieu in connection with a case you had.
Okay.
And the other one was lodged by Mr. Molanto against a full court matter in which you sat with acting Judge Peterson and again the retired Judge Lieu. The one that remains outstanding is one lodged by Mr. Patekile against you.
Yes.
And Judge Lieu again, and I mean,
Yes.
these are complaints that were lodged by convicted parties who were aggrieved with the result of their cases for one reason or the other. All 3 serving
Sentence.
terms of imprisonment, yes, somewhere. Do you recall the one launched by Mr. Patekile, and can you just tell us briefly what it was about and at which stage it is, if you know?
Okay. Yes, the one of Mr. Patekile, he was an accused before me in 2016. When I was sitting on circuit in Mokwasi, I convicted him and his co-accused and sentenced him. This year in August, I was made aware of a complaint by him against me. The first complaint was that I refused the prosecutor to call certain witnesses in the matter. And the second complaint was that I colluded with the police and the state to have him convicted. And thirdly was that I was refusing to have the record of the proceedings transcribed and reconstructed so that he could get the full record of proceedings. So when the complaint was brought to my attention, I then called for the file because the first two I know that I could not really do anything about. The fact that he's accusing me of having colluded with the state and the police. I dealt with that matter. I gave judgment in it. If he was not happy, he could have brought an application for leave to appeal, which was never brought to my attention. But the one that I was concerned about was the fact that he was accusing me of refusing to give him the record of proceedings. I then requested the registrar of our division to bring the file to me. And immediately when I asked for the record of proceedings, it was there in the file, complete. And I replied to the complaint that the record of proceedings is in the file and it's complete and it's available for Mr. Particular to access it. And that is as far as I could take it. I could not give him advice on what he could do once he's got the record because he was represented during the trial. He was also at the time when he wrote the complaint. No, the complaint was just an affidavit. But I just highlighted the fact that the record is there and it's available for him to access it and take whatever necessary steps that he can take. And I have replied and I'm still awaiting the outcome.
All right.
Yes.
Well, a record of court proceedings is never for the judge, the presiding judge to give anyway. That's something to be dealt with the registrar of the court.
Yes, that's why I'm saying it was not even brought to my attention that he was looking for a record and whether the record was not complete or not complete. If there was a reconstruction that was required, it was not. The only time I heard that Mr. Particular had a problem was when the complaint was brought to my attention.
Do you have any reported written judgments?
Yes, in my application, DCJ, I've stated the S versus Mataba case. That is a reported judgment that deals with DNA evidence.
Is it the only one?
Yes, that's the only one so far, DCJ.
But have you written other judgments that have not been reported?
Yes, a lot, DCJ, a lot of judgments.
Okay. Do you have any reserve judgments?
Currently, yes, I have 3 reserve judgments, but I'm still within the norms.
All right.
Yes, it's recent judgments that I've reserved, DCJ.
Okay. Well, I'm asking particularly about the ones that are listed in your application form, some which were had in May.
No, those ones have been handed down, DCJ.
All right.
All of them, yes.
Okay. What is your record in terms of producing judgments? Do you generally deliver them promptly or do you delay them?
Generally, I deliver promptly, DCJ, yes. If I would say I have a delayed judgment, it would be about 3 months and a couple of days or a couple of weeks, 1 week or 2 weeks. But I've never gone beyond 4 months, DCJ.
Well, perhaps to round off and not to be a Scrooge, I should mention that the law bodies who have commented on your suitability for this position all laud you for various things, including the role you play in mentoring everybody who happens to be around you, from those aspiring to join the professions to your colleagues.
Yes,
So
DCJ,
keep
I'm very
that up.
passionate. I'm very passionate about that, yes.
All right. Thank you so much, Judge. I'll hand over to the floor to question you, starting with your JP, Judge Hendricks. Judge Hendricks, are you ready?
Yes, thank you very much, Djaje. Good morning, Judge Djaje. How are you?
I'm fine, JP, thank you.
Thank you.
How are you?
I'm fine, thank you. Thanks for
Okay.
asking.
Thank you.
You mentioned that you acted previously in the position of as Deputy Judge President. That is April to June 2019.
Yes,
And
JP.
you are also currently the acting Deputy Judge President.
Yes, JP.
Yes. Now, how do you see your role as Deputy Judge President in our division? In other words, what does it entail and what is your vision?
Okay. As the Deputy Judge President in the division, my role is to support you as the JP, to understand your vision as the JP, and to align myself with your vision. And I do understand what your vision is, JP, in the division. And ever since I've been acting, especially now after appointment in August, I have strived to align myself and support you as the JP of the division. And in terms of the Act, the role of the JP, in terms of the Superior Courts Act, the role of the DJP is to perform functions and duties that are assigned to the DJP by the JP. And also, in the absence of the JP, to lead the division. And that's what I intend doing if I'm appointed in this position, JP.
Yes. As recently as last week, I was out on circuit in Garankuwa, and you were in charge of the division.
That's correct.
You had to allocate cases and to manage and report back to me.
That's correct, JP. I
Yes.
did that.
Now, we do have challenges at the main seat in our court. And we also have challenges in the lower courts.
Yes.
Now, I have visited Mokwasi, Tlabani, and Rustenburg, and I also reported on that. And you visited Ganyesa.
Yes, I did visit Ganyesa,
Yes.
JP, and I did find that there are challenges in that court. I've discussed them with you. I don't know if you want me to go into those challenges that there are.
No, I don't think
It's
it's
not
necessary.
Okay, all right.
But even Potchefstroom, we face with challenges there, and you are aware of it.
Yes, I am aware, JP. As recent as last week, I spoke to the head of the office of Potchefstroom to find out how the courts are performing and how they are dealing with those structural challenges.
And we need to visit all the lower courts in the province.
We are in the process of doing that, JP, and we will be visiting all those courts.
Yeah. Now back to our main seat, the challenges there. Did you visit downstairs at the records office?
Yes, I did,
And what are
JP.
the challenges?
The challenges that we have in the records office, it's filing space. We have a lot of files and we do not have enough space. However, through your initiative, JP, there are measures that are put in place now to create more space. We've got what we call consulting rooms, robing rooms for counsel in each court, and those rooms can be utilized to create more space for filing. There was also a challenge of the capturing of files when they come back from the typist, because the ladies who are doing the capturing were only using one computer. And I remember on a day that myself and you were taking a tour downstairs, we immediately called the IT official to come and address that problem, and he attended to it. He made sure that a second computer was installed so that the capturing process goes faster.
Thank you. And there are also backlogs, and we are in the process of dealing with them through pre-trials and case flow management. Can you please elaborate on that?
Yes, JP, we indeed do have backlogs, and one way of us dealing with those backlogs is through case management. As acting DJP, I have that responsibility of doing the pre-trials in the division from Monday to Wednesday. And as and when I go through the pre-trials and find those backlog cases, I bring them to your attention so that they can be case managed. Some of them I have case managed to make sure that they are brought to finality. We are definitely dealing with the backlog. We also have a backlog as far as the criminal trials are concerned, and that is why you even had to go on circuit for the past 2 weeks. And we have a meeting that we need to discuss how to also deal with those backlog criminal cases on circuit.
Yes. Thank you very much, DCJ.
Thank you, Judge President. Premier, Let me first take this opportunity to welcome you to the proceedings. I'm sorry I did not acknowledge you previously. I did not see you. Go ahead.
Good morning, DCJ. Good morning, ladies and gentlemen. Good morning, Judge Djaje.
Good morning, Premier. How are you?
It rhymes nicely, Judge Djaje.
Thank you, Premier.
But firstly, out there in the Northwest, there's a perception that law enforcement agencies and the judiciary are slow in dealing with corruption cases. What do you think the judiciary should do to dispel and disprove this perception?
Thank you, Premier. It is a concern and a valid concern indeed. As soon from the judiciary side, we can only be involved once the cases have been brought to the court. And once the cases come to the court, as I was alluding to before, we've got a pre-trial process. And we pre-trial cases because we want to see how ready the matters are. And we ensure that there is compliance so that matters can start promptly and be finalized immediately. Not at the same time, but we can strive to ensure that matters start and they are tried before court and are finalized as soon as possible so that we can instill that confidence by members of the community in the judiciary. Because once we lose the trust of the community, then we might as well pack up and go. So from our side, what we can ensure is efficiency of the courts in finalizing those type of matters.
Thank you.
Thank you, Premier.
We will be introducing the traditional courts soon in the Northwest.
Yes.
What do you think should be the relationship between the judiciary and the traditional courts?
Thank you, Premier. Yes, I am aware of that process, and the traditional courts, I know that their appeals are dealt with in the magistrates' court. And the relationship that can be created is that of coordination and working together. And if there is a need for training as well, there should be training of the presiding officers in the traditional courts. This done so that as they would be courts dealing with disputes, we need to have communities having confidence that their disputes will be resolved. And for you to have confidence that your dispute will be resolved, you need to believe in the capability and competence of an institution. And we can do that by also introducing some kind of training for the presiding officers in those courts as well.
Very much. Last question from my side. I think your appointment will greatly improve gender representation in the division. But I think much must still be done to broaden that gender representation. And what do you think is going to be your contribution towards that objective?
You are right, Premier. Definitely, we still need to do much. For the fact that I'm the only black female in the division is concerning. And to invite acting judges, it's the prerogative of the judge president. But as a deputy judge president, because I have seen that he's an inclusive leader, he does discuss with me, and I can advise and discuss and suggest to him how we can approach this. In fact, what I can say to you, Premier, that as we speak now, what the judge president has said and has done, I know for sure that he has done that. He has written to various law bodies to give him a list of people that can come and act in the division, especially black women. And that is why I'm saying that we currently have 2 black females that are acting in the division. So we are moving in that direction, and soon the picture will be different.
Very much, Judge.
Thank you, Premier.
Thank you, Premier.
Commissioner Dodovu.
Thank you very much, DCJ. Good morning, Justice Judge.
Good morning, Commissioner Dodovu.
Thank you. I'm going to ask you two questions, and these questions, I asked them to your predecessor, Judge Hendricks, in 2019,
Okay,
when he applied for the same position
okay.
that you are applying for. The first one, to become a DJP is a senior position, a leadership position within the division. And there are systematic issues that are facing the judiciary, like, for example, the backlogs, the delay in issuing judgments, the language that the judges are using, the modernization of the judiciary itself. If you can be placed in that position of DJP, what do you think would be the improvements and innovations that you can bring forward to address those areas?
Okay, thank you, Commissioner. Firstly, you mentioned the issue of judgments, delayed judgments, and the language that is used. Judges speak through their judgments, and if you cannot write a judgment, then it's a challenge. We do have training by the South African Judicial Education Institute that does from time to time hold training on judgment writing. However, as a DJP, the other role that I would play is that of mentoring and guiding acting judges and other judges as well. And from time to time, we need to hold discussions, even if they are just informal, just concerning judgment writing, and share skills that can enable us to deal with judgment writing. And that would also include not interfering with the style of writing, because a person's style it's a style and you cannot interfere with that, but the manner in which the judgment is written, because at the end of the day, it becomes the judgment of the division and not an individual's judgment. So sharing skills and tips on how to deal with that will be one of the priorities that I will be doing. In fact, currently what we do is that we always say 4 eyes are better than 2. So once a colleague has written a judgment, they would bring it to either me or the JP and would ask for my comment on that particular judgment. And in that way, one is able to make inputs and suggestions on how to approach certain issues. So it is happening, it's ongoing, and I would continue doing that as well. As far as modernization, you mentioned that, Commissioner. We have all, as I said, we've got 4 permanent judges in the province. All of us, we've attended the case line training by JP Mulambo, and all that we're waiting for is the rollout. I believe that we are all capacitated to deal with matters on the virtual platform. In fact, we do from time to time have matters that we hear on the virtual platform. And if that can be rolled out, case line can be rolled out in a division, it will also assist with the filing space that we need so much, because we have files all over. It will really assist. But we are ready, and if it can be rolled out tomorrow, we will hit the ground running.
Thank you. Second question. There's been a talk to have a second court in the area of Klerksdorp, Potchefstroom, an area which is infested by gangsterism and lately zamazamas. And in my respective view, I think that is needed. What could be the impediments to the establishment of the second court, or is it still in the pipeline to ensure that it is there in an area that is having so many criminal activities taking place?
Okay. Thank you, Commissioner. Currently, there is a circuit court that is sitting in Klerksdorp. I think maybe what we need in Klerksdorp is a local division. Yes, and...
I meant the local division.
Oh, local division, oh,
Not
yes.
the second court,
no.
per se, yeah,
Okay.
local division.
I agree with you. Klerksdorp is a very busy place. Commissioner Dodovu, as far as criminal cases and civil cases are concerned. I am aware that the JP has, as recent as around the 25th of September, compiled a report on the, should I proceed? Okay, all right, thank you. Yes, the JP has compiled a report on the rationalization of courts in the province. And in that report, he has proposed that there should be a local division in Klerksdorp with additional judges appointed so that they can deal with the workload in Klerksdorp. In the meantime, we have a circuit court that sits in Klerksdorp from time to time. The JP as well has also shared his vision that he would like to have some of the unopposed motions heard in Klerksdorp because there is a lot of work that comes from that area, Klerksdorp and Potchefstroom, Commissioner.
Thank you, DCJ.
Thank you, Commissioner. Commissioner Moimang?
Thank you, DCJ. Good morning, Judge Djaje.
Good morning, Commissioner Moimang.
Just 2 questions from my side, but both of them are based on the judgment that you gave in the matter between Piedmont Global, the chairperson of the Northwest Gambling Board.
Yes, Commissioner.
The interdict that was granted by the court on the 20th of March 2018, following the objection that was lodged by the applicant to the gambling board on the I think it was in 2016. Don't you think that sometimes courts needs to be more cautious in terms of granting interim interdicts? The second one relates to the reasons that you advance for dismissing Piedmont's application. I think my understanding is that you were a bit cautious in terms of interfering with the process set out by the decision maker, in this instance, the board, and also you were cautious in terms of interfering with the work of the executive. In a nutshell, you exercise judicial restraint and deference. What is your understanding of judicial restraint and judicial activism? Thank you.
Thank you, Commissioner. On the first question of courts being cautious when granting interim interdicts, what I know, Commissioner, is that we have requirements of an interim interdict, and that is what the court dealing with such a matter should be looking at, whether the applicant has satisfied those requirements. And once the court is satisfied that the requirements are satisfied, then the decision has to be made. And that is as far as I can take it. In the Piedmont matter, I understand your question to be, what I understand to be judicial difference?
Yes, because you dismissed the
Yes.
application
Okay, all
by
right.
Piedmont to challenge the decision to award the casino licenses.
Okay. Firstly, as judges, Commissioner, we deal with matters according to the facts that are before us. And maybe, in fact, I should also state that the DCJ sat on appeal in that matter, so she was one of the judges forming the panel in the Supreme Court. But what we do as judges when we sit with matters, Commissioner, we consider the facts and the circumstances that are before us. And we decide the matter based on what we see. And in that matter, it was a review application to review the decision of the board. And I could not find any reasons that the board was wrong in its decision. And that is how I decided the case and dismissed the application of Piedmont. I don't preside in matters with fear, Commissioner. I hold the oath of office dear and close to my heart. And whenever there is a need to find that a decision by the executive was not proper, I will definitely deal with that aspect properly, Commissioner.
Thank you, Judge Djaje. Thank you, DCJ.
Thank you, Commissioner. Just on the merits of the Piedmont trilogy, because it was actually 3 massive matters that you had dealt with there.
Yes,
I can confirm that the SCA confirmed your thinking and conclusion resoundingly. Well, one does not know what the Constitutional Court will say if the matter goes there, but the SCA endorsed your good thinking.
And in not just the SCA, DCJ, senior judges of the SCA, DCJ. So it was a boost of confidence. And for me, having sat alone in that matter for 3 days,
Yes.
and the SCA, 5 judges sitting for 2 days. So it was really a boost of confidence.
Well deserved.
Thank you, DCJ.
Commissioner Makwanesh?
No, thank you very much, DCJ. Good morning, Judge Ali.
Good morning, Commissioner Mangwanisha.
Yes, according to you, what are the 4 strategic challenges facing the judiciary in the 21st century?
Firstly, it's, I would say, confidence in the judiciary, competency, if the judiciary is competent to deal with matters, modernization of the courts in the current times, and I would also state structural challenges that we face in our courts, Commissioner.
No, thank you very much. Have you ever been in a situation where there was a strategic misalignment between the leader and the other colleagues? And if yes, how did you intervene and what were the results?
I would say in the High Court, not really, Commissioner, but if I think back to the Magistrate Court, there was an incident where there was a dispute between a colleague and the Regional Court President at that time. May her soul rest in peace, she's passed on. And what I did, I spoke to the colleague first to hear what the issue was, and discussed with the colleague on how to approach the issue, because confronting the leader was not the appropriate way to go about it, because once a person is your leader, you must show some kind of respect to that particular person. And what I did with the colleague, I requested him to show some kind of respect and calm down, because the other thing is, if emotions are running high, one is not able to control the way you would deal with an issue. And I then requested that colleague that if you are humble and you are calmed down, you are able to approach and reason your complaint well with the president. And fortunately, that is what happened. The colleague did listen. Even though I was young in the regional court, but I did command some kind of respect from my colleagues. When I joined the regional court, I was 30 years old. And I had colleagues who were much senior and much older. And this particular colleague was much older than me. But he did listen and approach the matter the way I suggested.
Thank you very much, DCJ. Thank you, Judge.
Thank you, Commissioner.
President Petse?
Thank you, DCJ. Good morning, Judge.
Good morning, AP.
One of the challenges currently plaguing the judiciary is partly heard cases that seem to drift on and on and on without proper management, something which has the potential to bring the administration of justice into disrepute.
Yes, AP.
Could you please enlighten this commission as to the current status of the partly heard matters you have listed in the questionnaire under paragraph 17?
Okay.
I see three of them.
Yes, I had listed 3 partly head matters, AP. One of the matters has been finalized. The other 2 matters are very long matters. The one of Malonga, if I'm not wrong, it's a matter that's got 32 counts, ranging from murder, robbery, attempted murder, possession of firearms. And the other matter, it's the Mpembe matter, which is the Marikana matter, where the police have been charged. Those are very long cases. The challenges that we have in those matters, in the Mpembe matter, it's because the counsel representing the accused are all private counsel, they are not from legal aid. It becomes a challenge to arrange dates with them. But as a presiding officer, at times I have to put my foot down to have them agree to dates that we can proceed with the matter. The challenge that we had lately was that one of the accused was not well, and we could not proceed with the matter. However, in our division, a small division as ours, it becomes difficult for one to sit for a long period in a criminal trial. Because if you only have 5 or 6 judges in a division and you sit in the criminal court for over 3 weeks, it means you are removed from doing other matters in the court and your colleagues become overstretched with work. So the few judges that we have also, it creates a problem for one to finalize. However, there are measures that I do from time to time try and adopt to have matters finalized, and that is that I would set matters down during recess to push those matters. However, there are just some issues that come up that are beyond my control, and no matter how hard I would put my foot down, I'm not able to succeed.
But shouldn't the proper plans be put in place to ensure that once a trial has been commenced, then it is brought to a conclusion within a reasonable time and as expeditiously as possible?
Yes. AP, I can confidently say to you, we really strive to have matters finalized as expeditiously as possible in the division. In fact, if we look at the cases, the part-head matters that are not being finalized, those would be your very long and complicated matters. But if we could, really, if we could, we would have a judge sitting in a criminal trial for more than 2 or 3 weeks to have that matter finalized, especially these long matters with a lot of counts. However, with the shortage that we have, it is not possible. But I agree with you, AP, if measures can be put in place, we have more judges in the division, then I have no doubt we will definitely achieve that.
Thank you, Judge Djaje.
Thank you, AP.
DCJ.
Thank you, President. Minister?
Good morning, Judge.
Good morning, Minister. How are you?
I'm very well. I only have one question. With the pilot project on the digitization and modernization, it was chosen for Gauteng and the Northwest.
Yes, Minister.
What will be your role to ensure that this project in the Northwest does reach its intended objectives? It does come to fruition, we see it. What do you see as your role in helping the JP and the division as a whole?
Thank you, Minister. I have indicated, Minister, that all the judges in the division have been trained, have attended the training by JP Mulambo on case line, and all that I would then do is to have a refresher course, because the last time we attended that was in 2020, if I'm not wrong, JP Mulambo will remind me. And, okay, I see Minister is, okay, yes. I would support and assist the JP to have a refresher course for those judges who have attended the training so that we don't have any challenges and we can hit the ground running. We've got a Wi-Fi running, working perfectly in the division, and we've got devices that are working. We just need to have scanners where files would be scanned so that they can be digitized and be available on the system, but we are ready, Minister. It would just take a question of just to refresh ourselves and we can start.
Thank you, DCJ.
Thank you, Minister. May I just ask the cameraman, it's difficult to, to have to compete with the click of the camera while one is trying to listen to the candidate. So try to be, invisible as much as possible. Thank you. Commissioner Matolo-Dlebu.
Thank you, Deputy Chief Justice. Good morning, Judge.
Good morning, Commissioner Matolo-Dlebu.
How are you?
I'm fine, and you, ma'am?
I'm fine, thanks.
Thank you.
Mine is just, I just want to find out from you. Northwest is such a vast province, and the issues of gender-based violence and racism, they're very rife. From where you're sitting, as in the high echelon of the judiciary, what do you think can be done, maybe working together with the university to run workshops for communities and, making them understand the role of the law?
Thank you, Commissioner. Definitely, I do agree with you. The Northwest is vast and it's plagued by this type of cases. In fact, before I get to answering your question, recently I was dealing with a matter. It was a gender-based violence matter, and it happened in the deep rural areas of the Northwest. So serious was that matter that I was concerned that no one knew about it. No one was aware what was happening in that area, but it was shocking because from the response I saw in the court from the members of the community, it was saying to me that they are shocked by what happened. I agree with you that we can work with the university to conscientize our communities as far as these matters are concerned. Firstly, to have them reported and know that they should not just agree to withdraw such matters because they are very serious. In fact, you find in the rural areas that people tend to believe that we can get together and resolve this in the family. And it doesn't stop. It perpetuates. It continues because the aggressor feels that I can continue doing it. This person is not educated. They don't know what their rights are. They don't know what they can do. And I am involved with the University of the Northwest a lot. From time to time, they do ask me to come and address the students. And I knew those days there used to be a unit in the university called street law. I don't know what happened to street law. Street law was one program where you would have even students and some of the lecturers going out to communities and talking to different communities about issues like GBVs and maintenance and alerting them of their rights and what the courts can do for them and what is out there. If the university could revive that program, it would also be a tool to be used for communities to be made aware of these kind of matters and to know their rights and what is it that they can do when they are faced with such challenges.
Thank you, Deputy Chief Justice.
Thank you, Commissioner. Commissioner Marumachai.
Thank you very much, DCJ. Good morning, Judge.
Le kae re Marumafai?
No, ke a leboga, ke teng, maitso.
Ke teng.
I had occasion to read one of your judgments, which is part of the package. It is Names versus Herod. Do you remember that? That dealt with impeachable dispositions.
Yes, the section 29 of the Insolvency Act,
Yes.
yes, yes, I remember.
I'm not sure if you do
Commissioner.
have the copy of the judgment with you, or maybe we can just talk about it, if you do remember it.
I don't have it with me,
And
but I
perhaps maybe
remember,
even the-
I remember a little bit, yes.
Yes, perhaps even the facts you don't remember. Okay, we'll talk about it generally.
Okay, okay.
This case dealt with voidable dispositions.
Yes.
Section 29.
Yes,
And I was quite interested in paragraph 20 and paragraph 21 of this judgment. In 20, you say that obviously the liquidators must prove and allege.
Yeah.
And you state the things that they need to prove and allege, and correctly so. On the following paragraph, paragraph 21, then you say that the people who benefited from the dispositions, they also have to prove something. And for me, that's where perhaps maybe I kind of like lost you a little bit. I'm not sure if, because I'm not sure who proves what at what stage, and whether the other one is by law entitled to prove, or does it follow from whether the first one who brought the case to the court to set aside, if he fails to prove, then that's the end of the matter. Or even if they fail to prove, those who benefited from the disposition, they also have to prove. Like I was just kind of like confused with that, because my reading of section 29 is you have what the liquidators or trustees must prove, then you have a proviso, or rather the defenses. In other words, if these people are successful, then this must be proved. I'm not sure. Can you just clarify that for me?
okay. Thank you, Commissioner. Yes, what I meant was that in terms of section 29, the liquidators have to prove that there are dispositions that have been made. What the people who have benefit should prove as well is that the dispositions that were made during the ordinary course of business and were made not with the intention to prefer. And that's where I then said that they also have to prove that the dispositions were not made with the intention to prefer, and they were made during the ordinary course of business.
But that's where my confusion is. Like, who bears the onus of proof? Or are they both going to court to go and prove those things? Or one proves, and if one is unsuccessful in proving, then that's the end of the matter. Or if one proves and they are unsuccessful, this one should also come and prove their defenses. That's where my confusion is.
Oh, okay. You are right. It's a defense that is raised by the ones who are benefited, yes. And in their defense, they need to show. And possibly it might be a question of the word prove and showing, but in raising your defense, you need to prove to the court, because they are saying you made dispositions knowing that you are being liquidated. And you must then, in your defense, show that. But these dispositions that you have proven have been made, because they have to be proven. These dispositions that you have proven have been made were not made with an intention to prefer, and they were made during the ordinary conduct of business.
No, I do understand.
Yes.
Then my follow-up question, and this is my last one. It is in relation to, when we look at the voidable disposition,
Yes.
in relation to what the other trustees or the liquidators must prove, the issue of intention doesn't arise. But of course, somehow the legislature included intention in relation to the defenses,
Yes.
which kind of like makes the whole scheme not that understandable,
Yes.
which is different from undue preferences in section 30,
Yes.
where part of what the liquidators must prove when proving this undue preference is actually intention. Do you think that these sections, when you are dealing with impeachable dispositions, the way in which they've been set out from section 26 to 31 of the Insolvency Act, they are fit for purpose?
Well, when I dealt with that matter, in fact, I had to also deal with that issue of intention, as you are saying, because one has to see that, in fact, there was an intention as well. And it was a question of me deciding, how do I determine now, when I get to this one, how do I determine this issue of the intention? And when dealing with that matter, the only thing that I could look at was from the facts of the case and the conduct of the parties. and how they conducted themselves, because that's how the act is, and that's what it requires us to do. And in following it, I could only look at the conduct of the parties. And I'm sure when you read the judgment, I referred to the conduct of the
No,
parties in determining the intention.
No, definitely. Thank you very much, DCJ. Just to correct one thing, because the universities are very sensitive as to how they are called. We don't have the University of Northwest. It's Northwest University.
Oh. Sorry, Professor.
Thank you for bringing that to our attention, Professor.
Yes, and you are right, it's NWU. Yes, I'm so sorry. How can I forget?
Well, there's only one university in the Northwest, so one will know which institution you're referring to.
Thank you, Professor.
JP Mlambo.
Thank you very much, DCJ. Good morning, Judge Djaje.
Good morning, JP Mlambo.
Good. Just one small question from me. You were a regional court magistrate, am I correct?
Yes, JP.
And as DJP, if you are appointed, you will be assisting your JP regarding access to justice in the division.
Yes.
Not just in the High Court, but the whole division, am I correct?
You are right, JP.
Yeah. There are two issues I just want to raise, and I need your comment on them. One is, I think your JP will confirm this, although the Northwest does not have this problem that much, is we always have regional court trials running for long periods. And you find regional court magistrates having more than 10, sometimes 15 part-head matters under their belt. Do you confirm that?
I do, JP.
Now, what is your vision? How will you assist the JP in attending to this? Because it continues to be a problem.
Thank you, JP. Yes, you are right. It is a problem and it's concerning. I do know that at the PEEC meetings, the regional court president, although it's acting regional court president currently, attends those meetings, and that's where the challenges are discussed. And I would then support the JP in making those inquiries and trying to come up with the solutions to those problems. I know that from my experience now in the regional court, there are matters where regional magistrates would just agree to postpone without inquiring and stating really why a matter should be postponed. And that is concerning because they just easily grant postponements when postponements are not just there for the taking. A party must satisfy the court. And I would support and assist the judge president in that regard, especially with my experience of challenges that some magistrate would claim to be existing when they are really not there. I will say one example, JP, that you would find matters where in the morning when the court starts, the court is informed that the accused has not been brought from prison. And the magistrate would then agree to roll a matter over to the next day or to a next date without inquiring, calling the investigating officer, calling the prison authorities, why is the accused not brought to court? Is it a problem of transport? Be more involved in the proceedings so that you can get progress in matters and having them finalized. But I will definitely, from my experience, assist the JP in that regard.
Thank you. One last question from me. I heard you mention that you were in charge of the division when the JP was on circuit. Was it in Garankuwa?
Yes, JP, he was on circuit in Garankuwa.
You would be aware of the Northwest Gauteng dynamic in terms of access to justice. In fact, as I sit here as JP of Gauteng, I know of a lot of Northwest residents who live on the borders of Gauteng, who use Gauteng addresses to litigate in Gauteng.
Yes.
Do you have a view about how you can assist the JP attend to this? Because you've got a number of these areas that are northwest areas, but that are closer to Gauteng.
Yes.
About how to deal with this. Is it through the second sitting of the court or what? I don't know. I just wanted to hear you, since you want to be one of the leaders of the division.
Okay. What I know currently, JP, is that we do have circuit courts that are sitting in Garankuwa and Themba. And Garankuwa and Themba, those are the boundaries of Gauteng. Those are areas that fall in the municipal boundaries of Gauteng, but they are serviced by the Northwest. And we do have circuit courts that sit regularly in Garankuwa and Themba, and we are servicing those people. And we continue with that, still waiting to see what will happen. And I must say that the work has increased as well tremendously in those areas. In fact, that is why JP had to go there for 2 weeks. And he had matters that were long matters running for those days. So we are servicing those people through the circuit courts, and that's how we can alleviate the challenge of having those people trying to go to Gauteng.
Okay.
We are there, we are servicing them, JP.
Thank you very much. In fact, we hope the Musenek committee will assist us, because they've raised those issues with us in Gauteng.
Yes.
I'm sure they would have also have raised them with your JP in the Northwest. Thank you very much,
They
DCJ.
have, yes.
Thank you, Judge President. Commissioner Notjes?
Thank you, DCJ. Good morning, Judge.
Good morning, Commissioner Nokesi.
My question apparently is triggered by your discussion with JP Mlam. You indicated that in that division, you have a complement, the full complement of judges is 7.
Yes, Commissioner.
And currently, you only have 4 judges.
Permanent
judges, meaning that there are 3 vacancies. There are 3
Yes,
vacancies.
yes, Commissioner.
And as a result of that, you will have 2 acting judges. Why,
Yes.
why is not 3? What is happening to the 3rd judge? Because in my view, you are supposed at each given time to have 7 judges, meaning that if you have 4 acting judges, there must be 3 acting judges that you get, because that's what you have.
Okay.
Yes.
Yes. You are right, Commissioner. I did say we are a complement of 7, and we should have 3 acting judges. But that the 3rd acting position, the JP is in the process of working on it, so that we can have the full complement.
Yeah.
We did have, in fact, we've just started term now. We did have 3 acting judges. In fact, one of the acting judges that started last week started acting in a position of a retired judge who retired last week. Okay. Yes. Oh. Now, the 3rd one, the JP is working on it. So we will have an acting judge soon.
Okay.
The 3rd one, yes.
Okay, no, I was just concerned about this. You can't complain about backlog when you have posted and then you don't.
Oh, okay. No, we are working on it.
The last question I just want to get is, what is your view on something that keeps on troubling? For instance, regarding, in particular, the acting of magistrate, regional magistrate and district magistrate. Those magistrates will go and act when they have a huge list of battle-head matters in their division. That's one area. Also, that would extend even to judges who want to go and act maybe in the higher courts when they have battle-head matters in their division. Is that not disrupting the efficient functioning of courts, and how that should be responded to by the leadership of the judiciary? Thank you. That's my last question.
Thank you, Commissioner. You are right. It would disrupt a court if you take a magistrate out of a court when they have a lot of part-head matters. What I would discuss with the JP, because it's the prerogative of the JP to get acting judges, but I would suggest a solution that when calling a magistrate to come and act, there should be an inquiry into the type of matters that they're dealing with and their part-heads. Look at their role. In fact, talking from experience, when I was called and invited to act, I first had to make sure that when I go and leave my court, because it was a one-man station, I had to make sure that when I leave my court, I leave it with no part-heads, so that the parties should not suffer. And I believe that it should be done by all the JPs. When inviting acting judges from the magistracy, they should do the same.
Thank you.
Thank you, Commissioner Nikis. Are there any questions from the virtual platform?
DCJ?
Is that Mr. Klaba?
Yes, DCJ. Commissioner Klaba, I have no question. Thank you so much.
Oh, thank you, Commissioner. I suppose you just had to greet us. Well, we appreciate it.
Thanks, DCJ.
I have questions, Commissioner Barnard.
Yes, Commissioner Bernard.
Thank you. Good morning, Acting DCJ, Acting JP. All right, there's so many titles. All right.
Good morning, Commissioner Bernard.
Good morning. No disrespect intended.
No, I don't think DCJ would find that disrespectful.
Not at all.
All right. If I can just ask you, you mentioned, from the questions posed earlier, I think it was the JP, you mentioned that court visits are used to address challenges, and specifically mentioned that you and the JP needed to visit the magistrates' courts. But I've been listening to the sort of busy, the fact that there are these matters that are part heard and things are dragged out, which means that you face challenges in that regard as well. So my question is, and one accepts that physical visits are sometimes necessary, but considering the workload, etc., to what extent might the virtual platforms assist in liaising with magistrates, for example?
Yes. Thank you, Commissioner. You are right that it would cause some kind of a disruption. But as much as you say it's necessary, it has to be done. And I believe it's all about time management. In fact, how we've been doing it is that when we go on circuit, one would use the time to visit the courts that would be in the area that you are in. And as you drive from circuit on your way to the main city, you would then stop along the way and visit the offices that you need to visit. Or we also schedule it for during recess. When one is not busy with your judgments, then you make time to visit those offices. I do agree the virtual platform can also assist, but at times one needs to be physically there to see those challenges. And as I mentioned when the JP was asking me about the visits, I drove to Ganyesa. It would have been easy to call the head of office or have a virtual meeting with him and discuss over the phone. But when one is physically there in that station, you are able to see firsthand the type of challenges that they have. And you get a sense and experience exactly what they are going through. So virtual, yes, it can help at a certain extent, but the physical visits are just as important, Commissioner.
Thank you. And my last question is just, there's good feedback about your diligence and excellent track record, etc. But there are these matters that were mentioned, these 3 complaints. And I was just wondering, on page 14, paragraph 20 of your application, there's, asking whether you've got anything to declare or bring to the Commission's attention. They're not mentioned there, and I was just wondering about that.
Okay. Thank you, Commissioner. These are complaints that I received after I had completed my application. I received them in August, Commissioner.
Thank you very much. Thank you, DCJ.
Thank you, Mr. Panaj. Any further questions, colleagues? None. Unless there's something you want to say to us, Judge Djaje?
No, DCJ, unless I'm going to invite more questions. But I just want to thank the commissioners for the opportunity that I was given to come and present my case. Thank you very much. I appreciate it.
Well, we thank you too for throwing your hat in the ring for this important position and representing the women. You're excused.
Thank you, DCJ. Thank you, commissioners.